Welcome to week 12 on legal issues and corrections. We'll be looking at chapter 19. The chapter starts with a look at employment law. It sets guidelines, requirements, and standards for staffing decisions in a corrections agency. And human resource management is critical to smooth organizational operations. All correctional employees are considered correctional workers first, and then workers at their specialty. Staff within a prison are interdependent, which means they need to work with each other and even work with the inmates for the security, good order, and discipline of the institution. Training of correction staff is a vital part of maintaining a quality workforce. This is both initial and refresher training. It could include firearms proficiency, first aid, self-defense, emergency procedures, legal developments, and other aspects. Virtually all areas of a corrections facility, especially where staff work directly with inmates, involve exposure to legal liability, particularly if the staff are not properly trained. There have been some cases around a failure to train. Davis v. Mason County in 1991 concerned 4 separate incidents where citizens were arrested by sheriff deputies. In each case, there were evidence that persons were beaten and charged with offenses that were later dropped. In a Section 1983 suit, a jury found the county, the sheriff, and the deputies liable for constitutional violations. The appeals court affirmed and also found the sheriff and county were properly held liable for failing to provide adequate and proper training. The county was held liable or responsible for setting policy for the type of actions involved. The court said the county's failure to train showed a reckless disregard for or deliberate indifference to the safety of its citizens. The sheriff was held liable because he was a policy-making official with ultimate authority to train persons in his department. His actions constituted county policy on the matter of training. The appeals court found that many deputies were sent out without any training. Deputies were not given adequate training on arrest and search procedures, and there was no training at all on the legal limits to the use of force, and this fact constituted deliberate indifference to the rights of the citizens as a matter of law. In Board of County Commissioners v. Brown, the Supreme Court considered the injurious action of a deputy sheriff during a traffic stop. Reserve Deputy Burns grabbed a passenger's arm, pulled him from the car, and injured her. She sued, claiming the county sheriff and the county claiming that by hiring Burns, the county was liable for its alleged use of excessive force. The lower court found liability, but the Supreme Court disagreed. It vacated and remanded for determination of whether Burns' background made his use of excessive force and making an arrest a plainly obvious consequence of the hiring decision. At a minimum, to avoid liability for constitutional violations under Section 1983, agencies should ensure staff are trained in the basics of job performance in any area where their work may implicate constitutional requirements. Agency managers must ensure agency policies reflect the constitutional requirements. Another area of law in the area of corrections is equal employment. The Federal Civil Rights Act of 1964, Title VII, mandates that there is no discrimination in employment practices based on a person's race, color, religion, sex, or national origin. In the Equal Employment Opportunity Act of 1972, Title VII coverage was extended to state governments. In the Dothard v. Rawlinson case in 1977, Rawlinson was denied employment as an Alabama prison guard, correctional counselor, because she failed to meet the minimum height and weight requirements. And those standards were 5 foot 2 inches and 120 pounds. Rawlinson filed a complaint with the EEOC claiming sex discrimination. She also complained of the prison rule that barred correctional counselors from working in direct contact with inmates of the opposite sex. The EEOC gave her a right to sue letter, in effect transferring her case to the federal courts. The lower court found that Rawlinson, finding that the height and weight requirements would exclude more than 40% of females and less than 1% of males. This was found to show a prima facie case of sex discrimination. The Supreme Court concurred with the prima facie assessment, but felt this wasn't the end of the matter. The state could still prevail if it could show that the pattern discrimination was justified legally rebutting the sexual discrimination showing. The evidence showed that the prison system was rife with violent behavior by the inmates. There was frequent inmate-staff contact, correctional agencies were understaffed, and a substantial portion of the inmate population was made up of sex offenders. Due to these factors, the court said the use of female officers in maximum security prisons would pose a substantial security problem directly linked to the sex of the officer, and found a BFOQ, or bona fide occupational qualification, that justify the exclusion of females from Alabama Guard forces, at least in a maximum security prison. Dothard is a strange type of victory for the state, as the court found the work environment a peculiarly inhospitable one. There continues to be a difference of opinion among correctional administrators on whether it's best for officers of the same sex to be of the same sex of the inmate population. The option of placing in non-contact positions could impact on an officer's promotion potential because it limits the ability to show the ability to handle a variety of posts. The ADA, acted in 1990, prohibits discrimination on the basis of disability. In terms of corrections, this would apply in employment as well as inmate programs and services. Employment under the ADA, Title I of the Act provides that reasonable steps must be taken to accommodate an applicant or employee who is disabled if the person is otherwise qualified for the job. Disability means a physical or mental impairment that substantially limits one or more of the major life activities of the person. There is a record of such an impairment or being regarded as having such an impairment. Otherwise qualified is similar to the BFOQ exception to the Civil Rights Act. Discrimination is permissible if it can show that qualification standards, tests, or selection criteria that screen out persons with disabilities are job-related, consistent with business necessity, and such job performance cannot be accomplished by reasonable accommodation. Employers are expected to make efforts to make a job possible for a disabled person, unless doing so will create an undue hardship. There is continuing interpretation of what constitutes undue hardship, reasonable accommodation, and otherwise qualified. Undue hardship is defined as an action requiring significant difficulty or expense. Administrators can best show undue hardship if they can show an accommodation would adversely affect the security operations of the agency. If a person is qualified to perform essential job functions except for limitations caused by the disability, the employer must consider whether the person could perform these functions with a reasonable accommodation. It's highly desirable for administrators to adopt policy and procedures that show the administration is aware of the requirements of the ADA and is trying to accommodate them. Inmate programs and services under the ADA, Title II. Correctional officials must take reasonable steps to include persons with disabilities in the program services offered to other inmates. The first and possibly most significant aspect of accommodation is physical access. The ADA does not require extensive remodeling of existing facilities. New construction modifications, however, should be accessible. Program accessibility may mean relocating where activities are conducted. Another Act requirement is communication. It must be effective as it is with others. Example would be telecommunications devices for the deaf. Accommodations must also be sought for inmates who are mentally disabled. Special housing is acceptable, but inmates can't be excluded from the same kinds of programs and services available to other inmates. May be excluded when ineligible or incapable of participating without changing essential nature, or when including this would impose a threat to the health or safety of others. Agency policies should be revised as necessary to show that accommodations will be made as the need arises. This statement relates to the critical issue of the classification of inmates. At intake screening, the needs of any incoming inmate who is disabled must be identified. This also extends to asking the inmate whether any of her prospective visitors has special needs due to a disability. The goal always is to mainstream inmates with disabilities, unless doing so would fundamentally alter the nature of the program or service, or it would create an undue financial or administrative burden. Special program assignments present special challenges. To the extent possible, inmates with disabilities should be assigned to classes, vocational training, work programs, other activities. Eligibility requirements for those programs should not exclude inmates with disabilities unless it can be shown that the requirements are necessary for the service to be provided or for the activity to take place. In Pennsylvania Department of Corrections versus Yeski was sentenced to 18 to 36 months, recommended for service of sentence in the state's motivational boot camp. Successful program completion could lead to parole in just 6 months. However, Yeski's hypertension led to corrections officials denying him program participation. He sued, alleging an ADA violation. The Supreme Court held the ADA clearly applies to state prisons. The court disagreed with state claims that the ADA language is ambiguous, that the law was not intended to benefit inmates, and the fact that the inmate was held against his will removed the inmate from coverage under the ADA. So the court held prisons offer many programs that at least theoretically are beneficial, that the Act does not require the programs to be voluntary. Even the words did suggest voluntary participation. All prison programs would not be excluded. For example, participation in this boot camp program is voluntary. Other observations about the ADA: this applies to all types of state and local facilities. Some accommodations would clearly be too costly, such as providing duplicate law books for blind inmates, but readers for blind could be a reasonable accommodation. The ADA doesn't give inmates in prison industries the legal status of employees for the benefits of non-discrimination portions of the Act that protect employees. Auxiliary aids of some kind are ordinarily required. It's permissible at classification or intake to ask the inmate about his disabilities, so long as it is done to ascertain the abilities of the person to participate in programs and activities, and whether special accommodations need to be made. Tort claims. Chapter 19 talks about common law torts, that they may be brought against governments if there's a statutory permission to do so. In other words, if the legislature has waived its sovereign immunity to be sued. The most frequent tort claims made by inmates are for lost or damaged property, injuries, and medical malpractice. If the government is shown to be liable because of the negligent actions of the employees or agents, payment awards to the injured party are made by the government and not by the individuals who were negligent. This occurs provided the employee is acting within the scope of his or her employment. In this instance, the case will be defended by a government attorney, and the individual employee will not need to obtain counsel. A key advice to all staff is to act in accordance with agency policy, procedures, and training. If the employee is found to be acting outside his instructions or in violation of policy and practice, he will need to obtain his own representation if a tort claim or tort suit is filed against a corrections agency. The representation cost will be paid by the employee, or if insurance company